Hey, this is John Watts. Welcome to our video. This is from Redhead Sticky, who leaves a comment on a video about why am I getting a motion for summary judgment in a debt collection case. So, question is this: upon receiving summons, I sent dispute back in 7 days. I filed it with the court. I sent it to the plaintiff, that'd be the debt collector. Here's where I believe the trickery comes into play. 2 months pass, and wife gets a notice of hearing letter from the lawyer, not the court, but it looks like it's from the court. Now it states summary judgment hearing and is dated September 19, 2019. So the question is, why do I have to dispute again after I already did with the original summons? I filed a cross motion in December after looking at this in detail. I assume that this means a cross motion for summary judgment. Am I okay? I'm ready for court. Not the shy type and upset at the company. So let's take a step back. What is a summary judgment motion? Well, a motion of any type is where we're asking the court to do something. So a motion for summary judgment says, Judge, I want you to summarily enter judgment. So we don't have to go to trial. Enter judgment in my favor. Now, that could be the plaintiff, the debt collector filing, or it could be the consumer, the defendant filing that. And the judge is supposed to grant a motion for summary judgment when there are no factual disputes that are important, what's called a material fact that's in dispute. So all the facts are basically agreed to, or we give every benefit of the doubt toward the person who has not filed the motion for summary judgment. So if the debt collector files motion for summary judgment, they're saying no facts are in dispute, or give the benefit of the doubt to the consumer on any disputed facts. And they have to show that the law entitles them to summary judgment. So you get sued, you file an answer, and then the plaintiff's lawyer, the collection lawyer, files a motion for summary judgment. So why do you have to dispute again? Well, because it's a different part of the case. So the initial part is the complaint and then the answer. Those are just allegations. The plaintiff doesn't have to prove those allegations when they file the complaint. Now, they have to make sure that they can prove those, but the complaint is just what they allege. The answer is just what you allege. But at the summary judgment stage, this is where the court is now looking not for allegations, not for what the plaintiff says or what the defendant says, but looking for actual evidence. Okay, so now that can be what the plaintiff says in an affidavit or deposition testimony, interrogatory responses, same thing for the consumer. So it's just a different stage. And now you have to make sure that there are factual disputes that matter, or that the law is such that the plaintiff is not entitled to summary judgment. So typically this is Rule 56 under most states. So Alabama, also under Federal Rules Civil Procedure, it's Rule 56. So you got to make sure that you're responding in the right way at the right time, because there are time limits. And if you miss the time limit, you give up, you concede, and so you lose. And so you want to be really careful about that and make sure you understand what the requirements are in your state for how you respond to this. Now, it sounds like that a cross motion was filed. In other words, the consumer here is saying, I also asked for summary judgment. And that's fine. You do have to make sure that you responded to their summary judgment. So sometimes people, they get a summary judgment and then they file summary judgment. They say, well, it's obvious that I'm disputing the first summary judgment. Well, no, you've got to respond to it. Now, your response may be simple. See my motion for summary judgment, which addresses everything. And so that's the situation here. It is frustrating. I understand, what the consumer's saying here. But you just have to go through that process. And, everybody has the right to file summary judgment motion. If summary judgment's not granted, then the next step should be a trial. So you definitely want to keep an eye on your case. Sounds like you're doing this on your own. So make sure you know about any court hearings. Make sure you know about any things that are filed in your case. And as far as the let's see, notice a hearing letter from lawyer, not the court, but it looks like it's from the court. That may be the way it's done in your state. I know in Alabama, Sometimes a motion for summary judgment will have written either on the front page or the back page, here's when the hearing is set. Other times the court may um, send out an order itself. It just depends on what you do. But I'll say this, predominantly in the past, whoever was filing a motion in certain counties in Alabama had to call and get a hearing date and then put that hearing date in the motion, and that was your notice. And if you didn't do that, it would be automatically denied. So that could be what's happening here. And so anyway, hope that that's helpful. And if you are handling this on your own, definitely make sure that you're spending the time to get up to speed on the court rules and substantively what's going on. You can think of the court rules as the rules of a football game, a basketball game. I mean, you've got to know those rules. You might be the best player, the best athlete out there, but if you don't know the rules, you're going to lose because you won't know sort of the strategy involved. So make sure you understand the rules and make sure that you feel confident about your position. And if you do not feel that way, then get with the consumer lawyer in your state. And a couple ways you could do that. One is you could hire a lawyer, say, hey, take over. You could say, if your state allows what's called limited scope representation, you might say, hey, can I buy an hour of your time? Have you go through this? Give me your opinion on this. And I'll tell you, as lawyers, sometimes we do that. We'll have motions or briefs that are being filed, and I might get a brief from the other side, respond, and then take both of those to another lawyer and say, hey, I want you to read these. Tell me what you think are the strengths and weaknesses so that I'm prepared. I mean, I've got my own ideas about this, but maybe you can see it a little bit differently. So you might do that. And wish you the best of luck. Thanks for your good comment, and I'll talk to you guys in the next video. Bye-bye.